So today I'm going to cover two somewhat independent concepts or subjects. The first subject I will cover is history, legal history of eminent domain in India. I'll spend maybe about 15 minutes on this. Just want to give you a flavor of how eminent domain has evolved, how this idea, legal concept has evolved in Indian setting during last 2 centuries. So it's basically, I will give you account of modern Indian legal history of eminent domain. Main motivation behind covering this subject is to motivate students to dig deeper into this issue and try to find out how the idea of property was conceptualized in ancient India or medieval India, how property rights were defined. We look at property as a bundle of rights. There are different views, legal views on the property, but one of the leading views is to look at property as a bundle of rights. So as a bundle of right means that law, property law defines what you can do with your property, what others can do with your property, what you cannot do with your property, and what others are disallowed with respect to your property. So in that sense, any property or a system of property rights can be looked at as a bundle of rights. So from this perspective or any other legal perspective, it will be of interest to know how Indian system conceptualized, defined the idea of property. Similar to related to the idea of property would be eminent domain, because eminent domain is basically conceptualizing, giving legal framework to your right to your property versus the state. In ancient times also, several rulers, they built infrastructure, canal infrastructure were built, communities developed local infrastructure. And whenever infrastructure was developed, it meant taking over some private property. Therefore, it will be of interest to know how those legal issues were dealt with. I don't have answer to this, but I want to encourage you to look deeper or look past into our history. It will be something that will be great contribution to our understanding about law in medieval and ancient India. But I'm going to talk about last 200 years. Yesterday, we discussed how eminent domain is conceptualized, is defined as a legal framework in different legal orders in different countries. So in India, the first formal legal treatment of the idea of eminent domain can be found in the Bengal Regulation Code of 1824. This code was enacted by East India Company. So it was a company, private company, that gave us the formal code about eminent domain. And if you read Bengal Regulation Code 1 of 1824, it talks about the right of the company to take away private property for road building, for building of canal, and also for taking over land to expand salt manufacturing. Most of these, roads and canal, they have public purpose, though the motivation of the East India Company was commercial. But the point that comes out is from Bengal Regulation Code is that the use of eminent domain was, at least by way of presentation, was for public purpose activities, except for salt manufacturing. Similarly, Bombay and Bombay and Colaba and Madras Presidency, company came out with code for those areas also, those presidency also. And there also use of eminent domain was for widening roads, thoroughfares, street, basically public purpose was the main theme, main justification for company to use eminent domain power to take away private property. And this remained more or less position. The code was enacted later on. It became an act after in 1857. These codes were subsumed into Act 6 of 1857. But the main idea remained that the eminent domain is to be used for public purpose. And as to the compensation, they talked about East India Company, and subsequently 1857 Act, they talked about fair value compensation of land. Now, what is interesting is that back then, some provisions of law, even though the laws were decided, framed, enacted by a foreign power, but by at least in concept, they had some features that are appreciable. One is that the primacy of public purpose, that the land is to be taken for public purpose. And other was that in the first instance, they were not supposed to, the company officials were not supposed to force property owners directly to take away, to surrender their land. In the beginning was to be made by negotiating with the property owner to arrive at a mutually acceptable settlement. So in that spirit, today we do not have this provision. For the most part, independent India, property owners had no say when government decided to take away their property. But in the 1857 Act, there was a provision for government. The message was that government officials will negotiate with the property owner. Negotiation would be on the amount of property that will be taken and also the compensation that will be paid. If two sides failed to arrive at a settlement, then there was a provision for arbitration. So a set of arbitrators was appointed who decided what the compensation should be. So those were kind of somewhat appreciable feature of 2-century old eminent domain law when it took off. Early on, even though it was East India Company that enacted the code, but there was no provision for using eminent domain for private purposes, in the sense that a private entity could not go to state officials, company officials, and say that use eminent domain power and give me the land. In independent India, companies could go to state governments, at times central government also, and request them to use eminent domain power, take away land from property owners and give it to company. There are thousands, there are actually maybe millions of instances where eminent domain power was used in independent India for the benefit of private companies. But in the beginning, there was no provision for this. The first time the provision came in was through the Act of 1867, the Act 12 of 1863. The first time acquisition was allowed for private companies and individuals. But what is noticeable is that even though private companies and individuals could request the British Empire to acquire land for them, the ownership was not with the private company or individual. Ownership of the acquired land rested with the state, with the government, and not with the private companies. It is in 1870 that the scope of private purpose acquisition was expanded. The Act of 1857 actually, so let me have your attention here. In the title itself, it says, an act for acquisition of land for public purpose and for companies. It was in 1870 through 1870 Act that the doors were opened for land acquisition for private companies, and then once land was acquired for a private company came to own the land. This position was not changed, has not been changed till date. It's just that since 2014, since law has been enacted, acquisition of land for private companies has become difficult. But once government acquires land for private companies, the land rights vest with the company. The ownership becomes private. This provision has not changed since then. What also, the other thing that we did in 1894 Act was that the provision of arbitration. As I mentioned that in the beginning, there was in the beginning, the spirit was that the government officials will negotiate with property owner, with farmers, property owners, and try to offer them a price that was acceptable to property owners. But this practice was abandoned partly in 1870, but especially since the Land Acquisition Act of 1894. The practice for the convention or practice for arbitration was given a complete go by. Until date, it has never appeared on the horizon. So earlier on, it was arbitration that settled the dispute between government and property owner. But today, as you know, that the disputes between property owner and government, they start from ADJ court, additional district judge court. That's the reference court if you have dispute with government over compensation. And then this dispute can go to high court and in some cases, Supreme Court. So there's a lot of litigation that happens today because primarily because the provision of arbitration has been taken away with. So this is the brief history of eminent domain in modern India. If you have questions, I can take some quick questions. But I would like to encourage students to consider investigating this issue. Not only this issue, actually, we need to develop a better understanding of how property contracts, torts were defined, were treated in ancient times in Indian setting. What is the Indian legal position on different branches of law? It would be great to know. Questions? You have last chance to ask a question.
Sir, if I may ask,
Yes, please.
would you please throw some light on what is the analysis of law and economics on public acquisition of land for private purposes, as is being done here, that land acquisition is being done for, say, companies by the government by using eminent domain. So,
right. Yes.
Apart from whether law is permitting that or not, what is the analysis that law and economics does for it? Whether Coase theorem would say that it is leading to Pareto optimal outcome or not?
Okay, so that's a very good question. Hopefully, let us wait. Give me some time to answer this question. Part of the answer will emerge from what I have to say next. But we can revisit the question sometime in next 10-15 minutes. Okay. If I forget to answer the question, so do remind me. This is something that I intend to cover next. I'm going to now the question pertains to an issue that we are going to take up next. So we are going to take up the issue of land acquisition by self-interested government. We are going to talk about the situations. We are going to consider whether, if we consider real world governments, whether they make do they make efficient decisions or not, do they ensure Pareto optimality or not, do they ensure Kaldor-Hicks efficiency or not. So we are going to discuss some of these issues, and I will try to avoid use of notations, but some are, what is that? No, declined. Okay, all right. So question, let's start by asking questions. Can full compensation ensure that taking will be in public interest? When I use phrase, word takings, I would mean eminent domain or land acquisition. In continental Europe, in US also, uh, land acquisition, use of eminent domain is also known as takings. So takings means government take away, taking away of properties by government. Question we want to ask is there a link between compensation amount and efficiency of government decisions to use eminent domain? Yesterday, I argued that yes, there's a link, there's a close link. If compensation amount is too little, then government will over acquire land. This begs the question: if compensation amount is increased, if compensation is full compensation, by let's now let's take few seconds to define the concept of full compensation. To define this concept, I want you to think of two situations. Situation one, you have your property. Your property could be a farmland, or it could be any other property. Situation one, you have your property and you use it the way it is permitted by law. That's situation one. Situation two, in situation two, I want you to imagine that you are going to lose your property, but you are going to get money in lieu of losing the property. What amount of money will make you indifferent? You would say, okay, I feel equally okay in two situations. The amount that will make you equally good, the amount that you receive in lieu of your property, but makes you feel equally good about you are okay losing your property, you feel no bad at all. So that amount is called full compensation. Question we are asking is full compensation guarantee that government takes decisions in public interest? It's the social cause that they will follow. And therefore, related question is, can we justify full compensation on the ground of efficiency? Or can we justify less than full compensation on grounds of efficiency? Then related question is, what is the role of judiciary? So judiciary is going to be around because it's a matter of property rights. On one hand, it's a matter of public policy from the side of government, but from the side of citizens, it's a matter of property rights, and therefore judiciary is going to be around. So we are going to be dealing with these issues. So first, we start with a simple example. We actually used yesterday, some version of that. Suppose eminent domain law, Land Acquisition Act, it requires full compensation. Think of a situation where you own a property and in your opinion, your property is worth R. R is the reserved price for your property. You think it's worth 100 crore or 100 rupees, doesn't matter. The monetary unit, the unit of account doesn't matter. Suppose it's worth 100. Okay. Now there are 2 acres of land, and there's an industrialist, a buyer who can make 210 if he gets both of these acres. And suppose we want to keep compensation amount C to be 100. Remember, C is for compensation, it is equal to R. That is your valuation of your property. So C equal R means full compensation. In this situation, I repeat, there are 2 acres. Each owner values each acre at 100. Therefore, in the present use, these 2 acres are worth 200. Government comes in, government takes away these 2 acres and give this acre to the developer, who will then use these acres and earn profit worth 210. In such a transfer of land from you to developer, there'll be net social gain, because in your hand this property is worth 200, but the developer can uh, increase its use by 210, and therefore society will gain by 10. If this transfer happens, we will say that it is socially efficient transfer. It is socially efficient transfer because society as a whole gained by 10. In this particular example, it also happens to be Pareto efficient transfer, because you are, even though you lose your land, but you get an amount that is equal to your valuation of your land. So you are not left any worse as a result of such transfer. So you are not left worse
Professor,
off.
sorry, can these slides be made a little bigger, please?
Okay, I should have checked that. It's full screen. What do you see on your screen?
We see the slide, but it's
Okay.
small. It's not very. Yesterday it was very clearly visible. So
I see. Now,
is it correct for all participants, or is it something in my system?
It's the same problem. The screen is, I think, small. He'll have to maximize the screen.
So if you can maximize the screen.
I'm trying. I will try.
Yeah, it's
Yes,
fine.
yes.
Okay, so when it comes to your demands, do not hesitate. You should not have waited this long to ask for full screen. From my side, I had made it full screen, but somehow it didn't go through. Now, can you see it the way you would like to see it?
Yes, Professor.
Yes, sir.
So in this example, where you get compensation that is equal to your valuation of land, such type of land acquisition are going to be Pareto efficient. They are also going to be Kaldor-Hicks efficient. They are going to be socially efficient. So from this example, it would seem that full compensation is the way to go, is the way to make land acquisition laws efficient. It would seem so. But there's a problem with this argument. This argument is true if we consider buyer to be a private entity. If a buyer is a private entity will look at the cost of land acquisition versus gain. In this example, if buyer is a private entity, buyer is looking at net gains of 210 from these 2 acres, and land cost is going to be 200. So a private buyer will look at profit of 10. So if there's a private buyer, then this is how calculations will be made. The private buyer would want these acres by paying compensation of 100 to each farmer. If buyer thought that V is not 210, if it was 190, meaning thereby if there was a project developer who could use these 2 acres but earn profit only 190, less than 200, that buyer would not be interested in taking this land, because land cost will be 200 and profit he will be making is less than 200, will end up making loss. So if buyer is a private entity, then this argument makes sense. So that full compensation can guarantee efficiency of land acquisition. But this argument does not apply if the buyer, the person, the entity that will be taking this land, using this land, is a government entity. Then this argument does not apply. Why it does not apply? Well, so this argument, if we believe in this argument, if we believe that this argument applies to government also, that would mean that the government will take away these 2 acres only if government can deliver benefit of more than 200. Participants, please verify if you are with me on this argument. If you think of a government who will take away these 2 acres, remember these 2 acres are worth 200 in their present use. Suppose there's a government and government thinks that it can use these acres to launch an industrial park or open a university or a hospital or something like this, and social benefit from that project are going to be more than 200. Government will go ahead and take away these 2 acres, will launch a new project on this land. That decision will be efficient. Question I have for you is, do you think government can take away this property worth 200 even though and then government takes away these 2 acres worth 200 and government implements a project on these 2 acres, the social benefit from projects are less than 200. Is that possible?
No, sir. In my belief, it is no.
So those of you who think that's not possible, you are thinking that government will behave like a private citizen. A private individual or a private company will look at monetary cost and monetary benefits. Whenever monetary benefits are higher than monetary cost, it will go ahead and demand land. That's what you will do if you have to launch a project on this land. Those of you think that government will also argue same way. You are thinking that government behaves like private citizens, private individuals, like private companies. You are, in your mind, you are applying models of civil liability to decision making of the government. What is a model of civil liability? Let's take a step as an aside. You know, in civil liability arises under tort law. Under tort law, if you end up harming somebody in a road accident or other accidents, then you have to compensate your victims. And if the compensation is going to be full compensation, then you will fully compensate for all the losses suffered by your victims. So it's that kind of reasoning that you are applying for government's decision making. That reasoning of civil liability applied to government, or thinking that governments behave like private individuals or private companies, is an erroneous assumption, is an erroneous way of looking at things. Why it is an erroneous way of looking at things? Well, you know that governments are run by politicians and bureaucrats. And politicians and bureaucrats, they do not always act in public interest. No government anywhere in the world, you don't have to really identify any particular government. No government on this earth, in the world, maybe in the universe, always follows social interests. It's like, one way of looking at government could be, we can have agency view of the government. For instance, you think of relationship between you, if you are an employee, think of relationship between you and your employer. Or if you have employed somebody, you can think of relationship between you as an employer and your employee. Your employee will do many things as you want them to do, but your interest and their interest are not aligned. Employee wants to maximize their welfare, their comfort. They want to minimize their discomfort. They want to get as high a wage from you as possible, and they do not care about every bit of business that you care. So there's a misalignment of incentives, your interest and employees' interest. Same logic applied to society versus government. Government, democratically elected or unelected government, you can think of them as you will think of relationship between employer and employee. Through social contract, through constitution, other political legal institutions, you can make a government follow social interest, but only to an extent. Politicians, governments, bureaucrats, they have their own objectives, and their objectives are not always in sync with social interest. You can think of many such examples. At times, economists are very fond of criticizing government, why government is making this inefficient decision, that inefficient decision. Well, and then impression is created as if government is not run by wise people. That view is erroneous. Most governments are run by smart people. It's just that they think differently. Their objectives are different from social objectives. Going back to our example, let's go back to this example. In this example, if buyer is a private company will look at benefit from this land versus cost of this land. But if buyer is a government will not only look at the cost and benefit of this land, it will also look at votes that it can get. Point is that leading political scientist, and I'm sure you don't need any political scientist to persuade you. You know that government decisions are not always guided by associated monetary cost. There's a large literature on political economy that makes these arguments. So that says that for politicians, especially in democratic setup, votes are more important than rupees and dollars. So government does not internalize the cost in the same way as private firm does. Government actors respond to political incentives, not financial ones. They respond to votes and not to dollars. This then creates a challenge, because in this example, we thought that we could achieve efficiency of land acquisition by making sure that the compensation is equal to full compensation. But if government is going to be guided not by monetary cost, but by something else, then we can't be sure that the land acquisition or eminent domain laws will be used in social interest. So I will pause here for a moment and I will let you ask some questions. So there's an empirical literature that shows that political considerations play a major role in government's decision making when government uses eminent domain. So in case of Israel, you can see that you will find that the neighborhood inhabited by Palestinians, they get many more eminent domain uses than other areas within Israel. In US also, it is very well documented that poor neighborhoods or neighborhoods inhabited by African Americans, Latina, government takes away properties in those neighborhoods more frequently than at other places. In our country, I have documented in my 2012 article that was shared with you yesterday, how different state governments have been targeting weaker sections to take away their land. So this shows that government decision, all these studies and many more show that government decisions are guided by political considerations. So they are major considerations. In such a situation, the question is, what should we do? What kind of mechanisms can take us towards efficient decision making? This question is addressed by Professor Hans Bernhard Schaeffer and myself in a paper. That paper has been shared with you today. You can read the paper. You can read only those sections of the paper where you see no symbols, no mathematics. So you can focus only on those sections without any mathematics symbols. You will get the main idea we are advocating in the paper. So in that paper, we argue that one way to. So what is the challenge here? Challenge is that governments are self-interested. They are not always guided by social interest. How can we make governments fall in line with social interest? We argue that there are two ways, there are two requirements to make government's decision more efficient. Requirement one is reduce compensation. Compensation should be less than full compensation. Other requirement is that let there be independent judiciary. It turns out that in all legal orders, whether you look at German law, American law, you look at Indian law, French law, doesn't matter. You look at developing countries, you look at developed societies, everywhere, compensation for eminent domain is less than full compensation. It is never full compensation. So in UK, the money payment, it will, whether you look at UK law, you look at American Constitution, you look at Indian law, the full compensation is never guaranteed. You look at Korean law, you look at UN resolution. So full compensation is never guaranteed. The rationale why full compensation is not provided for eminent domain, the legal rationale is the law. If you look at these laws, it comes out that the legal position says that we do not have to provide full compensation for eminent domain because eminent domain use is not a wrongful act. In accident law or in case of environmental hazards, there can be provision for full compensation because those are wrongful acts of harming somebody. But taking away your property under eminent domain is not a wrongful act of the state. The act is rightful because it is taken in public interest. And if something is taken, a step is taken in public interest and you suffer in the process, then you do not have entitlement to demand full compensation. You as affected property owner are also expected to make some sacrifice towards larger public good, towards larger public interest. And how do you make sacrifice? By accepting less than full compensation. That is the legal rationale provided for less than full compensation throughout the world. We argue that less than full compensation, it plays some important efficiency enhancing role. And what is the role it plays? We argue that it basically puts some check on decision making of the government. To give you, to explain the argument in simplest way possible I can, I want you to think of 3 projects. You can think of a neighborhood, a small town, big town. If you think of a big city town, think of a neighborhood. The neighborhood needs a public park. There's no park for children to play or for elderly to walk around. And its roads are also congested, so a slip road can be built. But this place doesn't have a golf course also. So if you have to take away land, then you can either build a public park or build a slip road, or you can build a golf course. So these are the options available. So I think you will agree with me that in such a situation, it is better to go for public park. The health benefit of public park will be greater than benefits from other 2 alternatives. If we can have only one of these projects, then land should be taken and used for public park. Next best arrangement is you use it to reduce congestion on streets, on road. And golf course perhaps would appear undesirable, socially undesirable use of land in that neighborhood. But political ranking of these projects can be very different. You know, maybe there are some rich families in this neighborhood who want a golf course and they can fund election. As a result, political ranking in this situation could be golf course is the first pet project of local government, followed by slip road and then public park. In such a situation, if politicians or government has its way, they will implement this project that is socially undesirable. They will not implement the socially best project, public park. If government has free hand, if government has to pay nothing by way of compensation, perhaps that is what they will do. And they are not answerable to anybody. This is what they will do. What will they? Question is, if now we bring in full compensation, what will government do? Assume in this case that the number of project affected people, families will be same. It doesn't matter whether you implement this project or that. You choose any of the 3 projects, number of project affected families are going to be same. If government provides full compensation, then property owners have no reasons to complain. Even if there is a court where government's decision can be questioned in terms of social cost and social benefits, people will not go to court because they are satiated with full compensation. So under full compensation, government can still implement its pet project, which is golf course, and ignore public park. Now, imagine a situation where compensation is less than full compensation. If compensation is less than full compensation and government take away your property, it hurts you. You are left worse off because you got some compensation that is less than what you have sacrificed. So under less than full compensation, property owners are left worse off. Since they are left worse off, they have incentive to go to court to question government's decision wherever they can question. Imagine a situation where compensation is less than full compensation, but government goes ahead, takes away these properties and implement golf course project. In that situation, property owners would want to go to court and say that, look, this is a bad project. They want to retain, their primary interest is to retain their land. To retain their land, they will go to court and say that, look, this project is not in public interest. And if judiciary has power to decide, to set aside all takings, land acquisition that are not in public interest, then judiciary will not allow such takings. So the basic idea is that less than full compensation hurts people. They want to go to judiciary to question eminent domain use by government. And if judiciary has the capacity, has the legal authority to set aside eminent domain use wherever it is not in public interest, we can get efficient outcome. Government will not be able to implement golf course type of projects. They will have to settle either for slip road or public park type of projects. This would be one way to restore some efficiency. But if there's a full compensation, then property owners do not care because they have been fully compensated, everything considered, and governments will get free hand. That's the nature of argument. That's the main argument we make. We use game theory tools in the paper. You can ignore mathematical model, but we show that less than full compensation is actually a good thing vis-a-vis government decision making. You know, we can actually relate to this idea to FRBM also. We have Fiscal Responsibilities Management Act, you know, that puts structure on how much central government and state governments can borrow. If center and state governments could borrow unlimited amount of money, then they will launch all kind of projects, socially desirable, undesirable. But if there's a limit to which they can borrow, that reduces the scope of inefficient decisions by the governments. So that is another application of the idea. So if we are using judiciary to arrive at more efficient outcome, FRBM Act reduces the purse, the size of purse available with the government to reduce scope of inefficient decisions. So I think I will stop here and let you ask questions.
Sir, there was a term mentioned in the previous slide, the first best outcome. Can you elaborate on that, please?
Yes, the first best outcome in this example would be that government takes away land and builds a public park on it. Second best outcome will be government takes away land, does not build public park, but builds slip road, which is next best project from social viewpoint. And third best inefficient is golf course. So first best is, you know, government takes away land whenever social benefits from taking are greater than cost imposed on project affected people. So that's condition one. Condition two is government uses that land to launch socially best project that will serve social interest best. So that outcome we call first best outcome. It's ideal on all counts. There was a question, about benefits. So there's an echo. So I don't know if that question has been answered. So a participant had asked me a question. Can you please verify if your question has been partially or fully answered? If not, please repeat your question. Then we have a question from Dr. Pramod.
Yes, sir, I understood it. Thank you.
Dr. Pramod, can we have
Yes.
this question, please?
Sir, what I am belongs to the economics background. What I understood is the eminent domain means the power of government to take the private property for public use without the owner's consent. Okay. So how to decide whether the project is the eminent domain or not?
You see, eminent domain. Please mute yourself. So eminent domain is a body of law. It's a legal doctrine that gives government authority to take away private properties in public interest. Whether eminent domain should be used or not, this decision rests with the government. So it's the government. Judiciary has no role here whatsoever. Government can decide
But
whether to use
indirectly,
eminent domain power or not.
but indirectly, judiciary itself is deciding whether it is coming under the eminent domain or not. Because after
No,
the agitation of people,
judiciary
yeah,
applies the test that are there in law. So if law says that eminent domain power can be used only for public purpose, then judiciary can ask, is a particular use of eminent domain is in public interest? Is it going to serve public purpose? Judiciary can ask these questions. Answers will have to be provided by the government. Government will have to justify that yes, this project serves public purpose because it will benefit so many residents, this and that. And if it turns out that the checklist that is there with the judiciary, if government fails on that checklist, then judiciary can set aside, refuse, say that this is not, it does not pass the judicial muster. So you are right, the initial step has to be taken by the government. Judiciary cannot tell government, use eminent domain for this project. The first call has to be taken by the government. Judiciary can then second guess and check whether the decision taken by government passes judicial constitutional muster or not. So under land acquisition act, for instance, there's a provision for social impact assessment. If a project is over more than 100 acres, then it is mandatory for the government to have a social audit to assess social impact of the project. And then in that assessment, experts are hired to document benefits from project and also cost imposed, social cost, environmental cost that will be imposed. So judiciary can look at those estimates, can hire other set of experts and check whether the estimates that government has come out with of benefits and cost, whether they are plausible or not. And if it turns out that benefits are less than social cost, then judiciary will say it is not in public interest and you can't use eminent domain power. Okay, next question, please.
Sir, if I may say, can I ask?
Yes, sure.
Sir, I don't know if we are able to consider that in our analysis. Generally, when land acquisition is done for a public purpose, which is being done or achieved through private participation, say for example, the setting up of a special economic zone, and there is land acquisition being done for setting up an SEZ. That land could be usually agricultural land, rural land. The land use changes from agricultural land to commercial. That land use by itself changes the value of the land by 4 times or 10 times also. So when we are thinking of compensation, we are thinking of the agrarian market. In that market, the value of that land was very little. By virtue of the change of land use, the value of those lands jumps to say 4 times, 6 times, 10 times something. If in those cases, is it okay to give compensation based on what was the market value in agricultural land market.
You see, Pratik, we have to look at this question. We can look at the question either from pure legalistic viewpoint or conceptual viewpoint or normative viewpoint. If we look at this issue legally, then law is very clear. You cannot take future appreciation into account to estimate compensation.
Right.
The value of the compensation has to be based on estimates of market value before land was acquired. What happens to its value post acquisition, that is not to be taken into account. So that's a legal position. We like it or not. The second view could be conceptually, if we apply the logic of full compensation. The logic of full compensation also applies with respect to date when land is being taken away, not what happens to its value afterward. But in real world, most of agitations that we have seen in our country by farmers have happened because they gave land, and that time they didn't feel that they were being shortchanged by the government. That time land was agrarian land, very little infrastructure, and they got market value or less than market value and felt nothing. They didn't feel agitated. Within span of years, those areas developed and the land prices skyrocketed. Then these farmers felt that we have been handed out peanuts for land that was worth crores, because land value appreciated post acquisition. So in real world, this is an issue. For political economy, this is an issue. An eminent domain cannot handle this issue. There are externalities, positive externalities, negative externalities also. Whenever railway project comes up, urban development project comes up, even road project comes up, land value appreciate. So at times people benefit also. They lose some land, but value of remaining land appreciates. So this type of things happen. An eminent domain is not in a position to deal with this issue. And thank you for asking this question. So my position, my view is that instead of using eminent domain with full compensation or less than full compensation, we should go for land pooling schemes. In land pooling scheme, you sacrifice some land, but not all of your land. So if there is a future appreciation that happens, you benefit. So land pooling schemes take care of this concern that you have expressed, and that's why I'm working on a paper where I show that land pooling schemes are better than eminent domain schemes. They are actually even better than even market transactions. Okay, I can take last question, then we have to end this session for the next session. So,
just one thing, I know it is
no, there's if somebody else with the question, I will. If there's nobody else with the question, then I can take next question.
So I had one question.
Raghav,
regarding-
you also took turn today. Is there somebody else who has not taken turn to ask a question? Okay, Raghav, you get the chance quickly.
Thank you, sir. So is there a good way to calculate the market value of properties in India? Because under the present law, there is either you can go by circle rates or comparable sales, both of which are undervalued due to tax reasons. So is it possible to know the actual market value of land in India?
In cities, it is possible. In cities, the land market is active, and you can. There are, one is that one can design mechanisms to elicit true market values. But to answer your question, in rural areas, it is difficult, very difficult, because land markets are dormant. In urban areas, it is possible to use, sale deeds as a reference point and then mark them up. It's an empirical exercise that will involve government and economists working together, because sale deeds underreport they do not report true market, true transaction price. Sale deeds, people underreport the transaction price. So we will have to mark them up, but that's one way to go about it. But then there are some more complex mechanisms. So some other time we can discuss them.